Yeah, hi friends, it's Harpreet Singh from Western Singh Law Firm. Today I want to discuss about payment of wages in California. What are those basic rules about payment of wages? So basically, when we talk about that topic, we have to look at Labor Code 212, which is the governing law for like the method of payment. Either there are any deductions you can make, or if you want to use some other convenient method of payment, what are the rules surrounding those? Uh, so when we talk about payment, obviously nowadays I think there is a trend of sending direct deposit to employees' checking account, and that's also a much efficient way. I think it's easy to manage the payroll reports, and also it's easy to see if the employee has received it or not instead of printing paper checks. But still, I think in a I think very significant manner, the paper checks are still used. So what? So who decide about the method of payment? Means the payment needs to be in cash or in check. So the law provides that if the employee wants the payment need to be done in cash, then the employer need to provide that in cash. Obviously, there are some requirement if it's reasonable or not based on the amount. But if you're talking about $600,000, then you have to pay that in cash, or you can also use a check. But if you're talking about the cash on demand method, you cannot have any deduction or any fees for such a demand from the employee's paycheck. Uh, because obviously, if you are asking like kind of a fees for every such transaction, which the employee has already earned, so basically it sounds like you are penalizing employee for choosing that payment of method. So that's not allowed under the law. So the next thing, it's the check or the account which you're using. If suppose you are sending or printing a paper check with a pay stub, and you're providing it to employee, so whichever check you're using and the account which is attached to it, your so-called business checking account, so that account needs to have sufficient funds for at least 30 days. And also in general, I think you know about, you should not give any person a check or a money which is due from an account which doesn't have any money to at the first, I think, at the first start. So the main purpose is obviously to avoid a situation where you don't have the money in your account and an employee's pay is already earned and you're giving that. And if it's intentional, then obviously there is a lot of criminal consequences involved in that. So it's so whenever you are providing paper check, make sure that account have money. And when we are talking about COVID-19, I think this pandemic has hurt everyone, every employer. So probably you have issues with your cash flow, but still make sure, because California law is very strict. And if you come across that situation, so you're basically violating a labor code, the employee can file a complaint with labor commissioner's office or the enforcement division of the Department of Industrial Relations. So you can get into trouble. There can be further investigations, or if it's a continuing practice, then further issues with that. So just make sure whichever check you are providing, the account has money at least for 30 days. Because an employee may not cash that check maybe within a week or so. Sometime means if you're talking about employees who are getting a good amount of money, maybe they have misplaced the check somewhere, and they deposit the check after a couple of weeks and you don't have the money, then there is an issue involved with that. So the law provide at least you need to have 30 days the funds in your account when you're giving a check. So The next thing about making payment to the employees, when you talk about the payroll and choices which you can use to deliver that money, those earned wages to the employee, some of the employer, when you're talking about like many employees who are mostly doesn't have bank accounts, so direct deposit, it's usually not kind of an option in that situation because the employee doesn't have a bank account, especially if you're talking about low wage earners. In that situation, sometimes employers think about some creative ways, and also it has been more generalized nowadays. So I want to talk about the prepaid debit card method. So if your employee doesn't have a checking account or a bank account, and you still want to have that provide the convenience to the employee, and still it's more efficient on your side to manage your payroll and all the documentation involved with that, so you can offer the option of having the paycheck directly sent to these prepaid debit cards, and through that the employee can get their wages. But the important thing is that the employee need to have a choice. Means you cannot force that policy on your employees, and you cannot have a policy that you will only pay through a particular prepaid card when your employee is asking, okay, means you can give me a check. You cannot force employee for such an option. Even if employee choose such an option, there are few things you have to make sure the policy or the vendor you're using for such accounts, for those prepaid kind of banking institutions, that at least one withdrawal needs to be free of cost. Because when you talk about prepaid accounts, there are some fees involved because those are not like your usual lending institutions, not your usual banks where you can go at their branch. There is no branch for um, most of these vendors. So they provide options that you can withdraw money from ATMs of certain banks or networks. So in that situation, the policy needs to be at least one free withdrawal once a month for these paychecks, because ultimately you are providing that option. And as we have discussed early in this video, that you cannot put a fee on use of any payment method on the employee's wages. So that's one of the requirement. Another requirement is that obviously we have discussed in previous video, providing wage statement is important thing. So you need to provide also the wage statement. If you have providing these wages through a direct deposit method, that doesn't waive the requirement of not providing a wage statement. Because usually when you have printed checks, you are providing that wage statement. That's usually the upper part of your whole pay stub. Means if you think about, if people are still getting in that way, um, so the upper part, it's wage statement, which mentions about your deduction, how you come, the actual check amount, what's the calculation behind it. So you need to provide that. In this situation, when you have a direct deposit, usually employers use a thing called employee portals, which have like all their wage statements and information about when a direct deposit was made. In such a situation, obviously, I think that's more convenient for employers. So there is no violation about not giving a wage statement. And it's also easy to manage for employees. They can just go there, download a PDF file, and just keep it on their computer, on their phone. So they have the record of that, and employer have the records of that. So it's more convenient, but you need to provide that option to. It's obviously, it's sorry, not an option. The option is about one, at least one free withdrawal from these prepaid debit card or similar instruments like that, and providing the wage statement when you are sending these direct deposits. So if suppose you don't follow the rules which we have mentioned about having the money in your account, or if you are getting the fees out of these wages for a choice of employees to have a paper check, if you are intentionally doing it, then there are criminal violations involved in this situation. So it's considered as criminal offense. It's a misdemeanor, and there are also civil penalties involved with that. And proving an intent, it can be proved through various ways. Either you can prove if there is a conversation involved where employer already knew that it's a violation of the law through their HR department. You have emails, text message, something like that, or circumstantial evidence through the activity of the employer, where employee mentioned them a couple of times that this is the law, I should get these wages without any deduction, or I should get these even if I want to deposit a check after 2 weeks, your account is showing you don't have money. So still means you can show with those circumstantial evidence that the employer had knowledge about it, but still employer took certain action which just created this violation. So in such a situation, there are criminal penalties involved. The employee goes to labor commissioner office to report these violations, and then further labor commissioner's office will refer this case for criminal prosecution to your local district attorney's office. And if there are evidence, then obviously charges will be brought. So you should not I think get into that situation. So it's very simple to follow the law, and these are very simple rules. And now there are tools also provided, either if you're talking about QuickBooks, FreshBooks, or whatever kind of books or software application. So it's very easy to keep track of these things, and it's automatic. You have a certain pay period, certain pay date. You just fill in those numbers in your QuickBooks or whichever software you're using, and it automatically sends these direct deposit, automatically sends in the employee portal these pay stubs. So you don't have worry about just keeping track of individual things. So the important thing is that establish those procedures and systems based on these basic laws. So thanks for watching these videos. So in the next video, we'll talk about further some basic laws about topics involved with employment law, and just try to try to provide you some basic knowledge about these things. So if you have any issues, or if you're thinking about, so at least you have that basic knowledge, so you can talk with any legal professional to improve your systems and procedures. Thank you.